Formalities of preparing a will. So we talk about what it is, and that's an important legal document. But so, what are the things that, like, what's the checklist of things that we should do?
Yeah, look, it is a legal document, and so every state and territory will have its own regime in terms of what needs to be complied with, and look, they'll be pretty much the same across every jurisdiction, but it's got to be in writing. So there's got to be something you can actually read, although that can be flexible in some states. But let's start from the presumption that it's best to have it in writing. The will maker needs to sign it in the presence of 2 adult witnesses.
Yes.
Blind witnesses are no good, so they actually do have to have sight, as silly as that sounds. But
so I thought you were talking about some term blind, but you're talking literally. Literally, somebody who's blind can't sign a will.
No, that's right.
Yeah, right. Okay.
It sounds silly, but that's absolutely right.
Yeah.
You've got to date the document because that gives it its time frame, and then the will maker and the witnesses should use the same pen.
How do you know? Like, how do you know if they haven't used the same pen?
Oh, it's pretty obvious.
Yeah,
okay. It's pretty obvious. And some people say, look, why is that? What's the importance of that? Well, because one of the formalities is that the witnesses and the will maker need to be in the same place at the same time.
Yes.
When that will gets to the probate office for administration after death, the only way the registrar of probates can ascertain that question is by looking at the pen. Now, if it's the same colour pen, the presumption is you're all together at the same time. Now, you could use 3 different coloured pens and still be at the same time, same place at the same time.
Yes.
But the registrar, won't know that. So it's as simple as that. It's just a question of satisfying the formalities by using the same pen. That's not to say that using different pens makes it invalid. It just means the process for proving the will is going to be much more difficult.
Is that the same for binding death nominations that we'll talk about soon?
No, I don't think there's any requirement to use the same pen for those.
Okay,
no.
So that's a legal thing to do with the will only.
Yeah, to satisfy that the formalities contained in the Act of Parliament of it itself.
Yes. Yeah. Okay. Great.
And the other thing is to be valid, the will must be made by someone who has capacity. Mm-hmm. So you need to actually understand what you're doing in order to make a valid will. And
the classic case there is if somebody has dementia.
Yep, or is under duress, and so their own in inverted commas will is overridden by somebody else.
Yeah, okay.
So it needs to be a freely made document by someone who understands what they're doing.
Okay, excellent. So that's the formalities or the checklist of preparing a will. What's going to happen in that case for those people if they should pass away now?
Yep. The first thing is that they won't have someone nominated to actually administer the estate. As I said before, the will appoints somebody to do that. So if you don't have a will, you've got nobody appointed to take over the estate administration. So that's your first problem.
So who ends up doing that then?
Well, you'll have this period where nobody has authority to do anything.
Okay.
And so there's a bit of a hiatus where everyone looks at each other and says, well, what do we do now? And so it's usually the person who is entitled to the greatest portion of the estate has to apply to the court for administration.
So a spouse?
Yep. Or one of the children.
Yep. So this is the classic case where if you're a spouse and you've got a main bank account in one person's name,
yep,
and that might be your transaction account, and the other person might have access to it, but it's not their account.
Yes.
In the event that person dies, the access could be
frozen. Technically frozen at date of death.
And therefore, the spouse would then not have access to that money until they go through the long-winded process of getting authority to administer the. Yeah, and then it could be much longer than that as well.
It could be, yeah. So you've got this period where nobody has authority to do anything, and then you have to wait for someone to step up and do that, go through the process, and then release the funds before it can be touched. So,
and what's an average time frame that you would expect that to happen in from the date of death?
That's a good question. It depends how complicated. Anywhere from 6 weeks to 6 months.
Wow.
Depending on how complicated, but probably on the shorter side of that period,
depending on the complexity.
That's right.
Yeah, but I guess the point that I'm trying to get across there is that it can take a long time, and so it can cause significant issues for someone who doesn't have things set up correctly there.
And you can even raise the potential for a dispute about who's going to apply for letters of administration.
Yes.
So someone says, no, I want to do it, then someone else says, no, I want to do it, and all of a sudden you've got a fight at that level, and that might delay things again.
And so that's where the 6 months could very much come about.
Absolutely. Yeah. Longer, potentially, if you have a dispute at that point.